SJC-12432, Mary Shiel v. John Rowell, and others.
Mr. Spallina, good morning. A timely time, a good time to appear before us where branches are falling all over the Commonwealth.
Hope you concentrate wonderfully on this case. So, good morning, Chief Justice, members of the court. My name is William Spallina. I represent the plaintiff appellant in this case, Mary Shiel, and we're here seeking to have the court change the law in Massachusetts regarding the liability of the owner of a land who has trees whose roots or branches protrude onto adjoining property. And I want to make clear we're not asking the court to make some grandiose revision in the law, opening the door to all kinds of lawsuits. We're seeking a very narrow change in the law that will prohibit or discourage claims that are not really serious, but allow people to seek relief either by injunctive relief or for damages where there is serious damage or impending or threatened damage to their property because of roots or trees.
What I'm not clear about is the scorecard.
Yeah.
And I didn't get it from both briefs. How many states follow the Massachusetts rule?
Yeah.
And how many follow this Hawaii rule, I guess?
Well, I think most states still are historically follow basically the Massachusetts rule with minor variation. It seems that there's three issues. One, what's the liability for a healthy tree? Two, what's your liability for a tree that is determined to be unhealthy? And three, what's your right to do self-help? Most states seem to say you have the right to self-help. You can cut down branches that are protruding or roots that are coming on your property. Other states, almost all the other states have some combination of if it's an unhealthy tree, there's liability. Massachusetts has that rule. And most states who have that also say that if you have no right to seek relief, either damages or injunctive relief for a healthy tree. So the only states that have changed the law in this regard, all of them have considered the Massachusetts rule, are starting in 1981, Hawaii adopted a new rule. 1985, New Mexico, 1986, Illinois, 2002, Tennessee, 2007, Virginia, and finally in 2012, North Dakota. It's important to note that all of them considered the Massachusetts rule and found it to be outmoded and no longer to be the way to go. They noted that Massachusetts rule came from a 1931 case, Mickelson versus Nutting, which this court reaffirmed in the 1983 case, Ponce, saying that no other case had been brought to this court's attention in which liability had been imposed in such circumstances. And except for Hawaii, which was 2 years earlier, that was true. Maybe Hawaii was considered an outlier, both figuratively and literally, but since then, the trend has started to shift. And what the courts seem to be noting is that we are now living more in an urban or a suburban setting and not in a rural setting where people own large tracts of land and it would be virtually impossible for them to police every tree that was on their property. And consequently, conversely, these days trees take on more significance because of the close density that people now live in. Trees border people's property, protrude huge branches over driveways where people park their cars next door. They can send roots. They can crack a foundation or a sewer pipe.
Under both the Hawaii rule and the Massachusetts rule, you can do self-help, right?
You can.
So we're not eliminating the sort of tension caused by self-help, right? We're just giving you another option. Is that what we're doing?
You're giving someone the option to go to court, which is important because the self-help rule basically says you're on your own, figure it out yourself. And as some of these courts have noted it fosters a rule of the jungle type mentality.
How do you help yourself? I mean, this is just sort of an aside. How do you help yourself with roots that are growing onto your property or a tree that's 100 feet tall?
Well, that's the problem. It's very expensive. If you want, and this tree is a very, very tall tree with very, very large branches protruding. You can't do it yourself. Not self-help means you can do it yourself or hire somebody. That's expensive. It costs a lot of money to bring a tree company in to cut down big branches. Roots would require you to hire a company to do excavation.
How does that work where, you know, my neighbor has this beautiful majestic tree on the property and I'm worried about my septic system, and I get a landscaper or somebody come in with a backhoe and just rip up all the roots on
Yep.
my side of the fence. Can I do that?
Yes, under the law in Massachusetts, you're allowed to.
And then the tree dies.
That's maybe one of the reasons why it would be helpful to give people the right to go to court if there's something serious or impendingly serious like that. Because
But I-
otherwise you foster bad feelings from the
I
neighbor.
guess what struck a chord in the other brief is what I think a number of us have seen in these neighborhood dispute cases where people come in and argue about trash being left out on the stoop. You know, they argue about a number of things. They run for injunctive relief. Is that what we're gonna be fostering if we rule in your favor, that when the acorns fall,
No.
and they dent the Honda, they're
No.
gonna come to court?
No, even though I think some people would like that, but what Hawaii did was they struck a balance. Hawaii said that in order to bring an action, there has to be a showing of imminent danger of causing harm. Overhanging branches or protruding roots constitute a nuisance only when they actually cause, or there is imminent danger of them causing sensible harm to property other than plant life in ways other than by casting shade or dropping leaves, flowers, or fruits. And so the courts in Virginia and Tennessee and New Mexico, in Illinois and North Dakota, when they reviewed the law and looked at the Hawaii law and looked at Virginia law, they decided who was one of the first states to sort of give the right to bring this action. They all found that the Hawaii law struck a sensible balance between not having all kinds of lawsuits every time an acorn dropped, but at the same time giving people the right to bring an action if there is imminent danger of causing harm or there is actual harm.
Can I ask how it works? So if my neighbor has a giant, very healthy tree
Yeah,
with a big branch hanging over my house,
yeah,
I can cut down that branch under Massachusetts law, right?
yes, and it will cost you a lot of money to do it.
Right. Under Hawaii law, I take it I can bring an action saying that that overhanging branch of that healthy tree needs to be removed by my neighbor because of the winds, or what, or can I not? How does that work?
No, you'd have to show under Hawaii law that it was imminent danger of causing harm.
What does that mean, imminent danger? Because
I
I
think
thought
you'd
we're
have to-
dealing with
you'd-
healthy trees, right?
You'd have to bring in someone to produce, you'd have to produce some evidence more than there's just a big branch hanging over. You'd have to show that the big branch for some reason is in danger of
Well,
breaking.
Well, I mean, okay, so in the last 2 days, we've had 60-mile-an-hour winds
Yeah.
and 80-mile-an-hour winds. Is that enough under the Hawaii rule? That a big branch and giant winds, or do I have to get an expert that would show that?
You'd have to get it,
I need a physicist to show that that level of wind with that kind of tree will knock it down?
you'd have to meet the burden of proving that there is imminent danger of causing harm.
I
And
thought you
don't
said
think a
there was
layperson-
self-help.
What's that?
I thought you said there was self-help both in Massachusetts
There
and
is.
Hawaii.
There is. So
So-
you
You
could
could
choose
cut
to do
down
that.
the limb yourself,
You could cut it down. You could climb up and cut it down, or
hire somebody.
Hire
And then could
somebody.
you could sue for damages, for costs? Is that it, if you did
can't
that?
sue, if you do self-help, you can't sue.
That's,
Can't.
that's literally going out on a limb.
Yes.
How long did you have that? How long did you have that?
So
That one,
we can't strike the record, I'm afraid. I'll have to let that one stand. The particular damage here was to the roof of your client's home.
That's true.
But and arising from resin?
Rising from whatever.
Algae? Was that the word?
Algae. That
But I
was-
mean, tell me what the process was whereby
Apparently-
those trees caused that harm.
What happens is if the branches are so big and the leaves cover and shade the roof, when it gets wet, it doesn't dry. And if it never dries, then algae starts to form on it. And that's what happened.
And in your view, would that fit the Hawaii standard of imminent danger of causing sensible harm? I'm not sure what sensible means. What does sensible harm mean to you?
It
Or in
means,
Hawaii, what does it mean?
it means something that's really an injury and not just something that you don't like because it's not aesthetically pleasing. And at some point, if the roof stays wet like that and the algae grows under the roof shingles, at some point it is going to be a problem. It's going to start to rot the roof boards, and then there's going to be a hole in the roof.
But I thought Hawaii says shade doesn't count. So this is, algae is caused by the shade, right?
That's true.
So this may not, Hawaii may not save your
But there's
client.
also water that comes from the branches too, so that could cause the algae.
Well, but-
And I think when
but
they
what
meant
about
shade,
the sap or the resin? I mean, where does that fall into the seed flower thing falling out of the tree?
I would say that that's, unless you can show that that's causing some harm to your property, that's not actionable. And that would make sense, because sap and resin is a natural product from trees. It's not really causing any harm to your property, because it can be cleaned off, and it's not gonna hurt anything, even if you leave it there.
Can I go back, I'd like to go back to the roots issue, though.
Sure.
So, the roots from the neighbor's tree is lifting up and destroying your fence.
Yes.
How does that work under the Massachusetts rule, and how does that work under the Hawaii rule?
Under both the Massachusetts rule, you have the right to dig out the roots. You would have to probably bring in a backhoe or a contractor to dig them up. Under the Hawaii rule, since it's destroying part of your property, you can seek either damages or injunctive relief against the adjoining landowner.
Or, and you can do self-help.
You can use self-help or use self-help.
So in Hawaii, it says, if such is not done within a reasonable time, so you can say to your neighbor, these roots are digging up or screwing up my septic system.
Or they're about to,
Okay, you have to fix it. You have to fix it within a reasonable time.
yeah.
Are they entitled to come onto your property to do so?
They're gonna have to. I mean, that's the only way it can be done. You can't pull roots out from standing on the other side of the tree and yanking them back onto your yard, unfortunately.
Okay, so you would have to allow them on your property for this purpose.
Well, yeah, but what doesn't really matter, because if your septic system is harmed, you want somebody to fix it. Whether you allow their contractor on or yours, someone's gotta come and dig up the ground, unfortunately.
Okay, and it says, and if not done within a reasonable time, the damaged or imminently endangered neighbor may cause the cutback to be done at the tree owner's expense. So if I say to you, get rid of these roots, and you don't do it within a reasonable time, I then say, I'm gonna hire somebody to do it, and I'm gonna send you the bill.
Yeah, or you can sue them for whatever the cost is and collect it from them. North Dakota, in their decision, used the phrase, does not materially harm, but then they adopted the White Cell decision from Hawaii, finding it voices a fair and rational solution, permitting a landowner to grow and nurture trees and balance it against the duty of the landowner to ensure their property does not materially harm their neighbors. So,
Then do I have an obligation in the situation that I'm just telling you to say to you, the roots are causing this problem? What if I don't say that, and then I just discover that my septic system has been damaged? Are you liable for that? Are you liable for that?
well, I mean, if someone sues, you can, the owner of the property where the tree is located can assert a defense of contributory negligence and say, you didn't take steps to timely stop this when you could have or should have known about it. Roots don't grow overnight. They take a long time to go over to a septic system. They will find a septic system if it's leaking, because whatever leaks out, a tree considers nutrients. And so the roots naturally gravitate towards it.
Now, this is not a negligence claim, it would be a nuisance claim, I believe, correct?
Yes, we're seeking we allege two theories in our case, nuisance, a public nuisance, or a private nuisance rather, and trespass.
Well,
And
trespass would not permit a comparative negligence
No.
defense, and does nuisance?
Well, I'm not sure if nuisance does. It probably doesn't. But nuisance also means that there is another hurdle that the person bringing suit has to overcome that's going to discourage a lot of suits, because you have to show that the conduct was negligent, negligent or an abnormally dangerous condition or activity. So mere falling of leaves or a branch that you think may fall in the wind is not necessarily an abnormally dangerous activity. So it would be a private nuisance, and you would have that burden to overcome that hurdle before you could even proceed with a lawsuit. The other states
But
have
how am I supposed to know that I'm causing a nuisance on your property?
Well,
If you have put up a tall fence or if it's a roots, how am I supposed to know what's happening below the surface?
you are going to either have to check, or you're just going to have to wait to find out. You know, if you know you have trees on your property line that are really, really big, you know that there's a problem or potential problem with the roots of those trees. The septic tank system argument may also backfire on someone, because tree roots wouldn't necessarily go to a septic tank unless nutrients were leaking out what the tree considers nutrients, which means you've done something wrong yourself. You have a defective septic tank. So when something starts to happen like this, usually it happens very slowly, so you'll see something to indicate it. But if roots from your tree are doing something to somebody's foundation of their house, then you're really living really close together. And at some point, you have to take that into account when you decide either have or keep trees that height on your property line. That's nothing different from if you decide to divert water in a way that may go over your property line to someone else's property, or leave a pile of gravel in your backyard that theoretically could wash out onto their driveway. You have to pay attention to what you're doing with your land.
Does it nuisance usually require you to knowingly do something of that, you're building fires, you're doing all sorts of stuff that's gonna interfere?
I don't believe nuisance requires that you know you're doing something that's causing a problem. But if you have a tree that's that big, at some point
I just don't see how this tree root theory complies with an ordinary case of nuisance. It just seems odd.
It could, if at some point the trees are breaching someone's foundation, it could be considered a dangerous activity because of what it's gonna do to the house. So at that point, you would be aware of what's going on. And that's when your responsibility starts to do something about it.
Did I hear you correctly when you said that Hawaii, I don't know if you mentioned North Dakota, in addition to having the option of going to court if the roots are destroying the septic tank or the fence, that you still have the option of self-help?
My understanding is they do, yes. I don't think I think probably every state allows self-help.
And so when you, and you support that, even though you're requesting a change?
Yeah, I think it gives everybody,
How does that reconcile with your view that, that this change will sort of affect an orderly community and get rid of the law of the jungle?
it gives you make a decision as to whether or not you want to engage counsel and try to prove that the tree is causing harm, imminent harm or serious harm to your property, or whether you'd rather just pay someone to cut the offending branches. But at least it allows you to, you have the right to go to court if you so choose. That's why.
Again, Massachusetts on unhealthy trees, do we allow, it's all self-help on unhealthy as well as healthy trees?
Yes.
Okay.
Yes.
But I believe dead trees are not covered by the Massachusetts rule, correct?
No, they're not. Yeah.
But
And that-
which
what does that
policy-
mean?
Oh, go ahead.
Sorry, I just want to make sure I understood your answer to the chief's question. What does that mean? Dead trees not covered, what does that mean?
You can be held negligent for damage caused by a dead tree branch in Massachusetts.
Okay.
Well, dead tree.
Or a dead tree, yes.
Wait, so a branch and a tree, or a branch or a tree, or?
Well, if the tree is, if the tree is sick and unhealthy, and a branch or the tree falls and causes damage, personal injury or property damage, you can be liable for that.
Okay, so it's not just self-help on an unhealthy tree.
Right.
It's an unhealthy tree that drops a branch.
Yes,
That you could already get recovery for.
yes, on the theory that the person was aware of what could happen if they didn't take the sick tree down.
Which of these approaches, in your view, the Massachusetts or the Hawaii approach, encourages more trees?
Which encourages more trees?
More trees.
Well,
The Johnny Appleseed.
no, Hawaii has a lot of trees. They seem to be doing okay. They've had this rule for 40 years. So I would say the Hawaii approach. And I'm really asking the court to change the law, as Hawaii has done, and not open the floodgates, but keep it just so that there are only serious cases coming into court. And this court should not be concerned with a flood of frivolous cases. 40 years ago, this court decided a case called Aegis versus Howard Johnson, where it decided that someone could maintain an action for emotional distress without any physical injury, and the court itself was aware of what the reaction to that was going to be, that there's been a concern that it would open the floodgates to all kinds of lawsuits. This court said that we are unwilling to deny the existence of this cause of action merely because there may be difficulties of proof. Instead, we believe the door to recovery should be opened, but narrowly and with due caution. And that case has been around, and it's worked out just fine for 40 years. So there's going to be no concern if the court adopts the narrow scope of liability that's in the Hawaii rule, and that's what we're asking the court to do.
All right, thank you.
Thank you.
Mr. McGinnis.
Good afternoon, Mr. Chief Justice, Associate Justices. My name is Dan McInnes. I represent the defendants in the underlying case, Mr. and Mrs. Rowell. We are here today to urge you to not change the law, to preserve and adhere to the valid legal precedent of the Ponte versus De Silva case, 1983 case from this court, as well as the Mickelson versus Nutting case, a 1931 case from this court. My clients are now facing the second lawsuit from Ms. Shiel from the exact same set of facts. We would suggest you this court need not even reach the issue of the vitality of Ponte, because this case can and should be decided strictly on the basis of res judicata claim preclusion. In our record appendix, the plaintiff, the parties are neighbors in Randolph, adjoining homes. There is a tree.
Isn't there, I'm sorry, the first case was a small claims case, right?
I'm sorry, Your Honor.
The first lawsuit was a small claims lawsuit.
It was, Your Honor.
So I think the contention is that this is damages since that small claims case was adjudicated.
Your Honor, I've uncovered at least four cases in which the three elements of res judicata are identity of parties, identity of causes of action, a valid final judgment on the merits of a court of competent jurisdiction. I have at least four cases that say that a small claims decision is a court of competent jurisdiction.
that's-
But
I
still,
give
the
it.
damage, I think what Justice Lowy's saying is that the damage it's a continuing damage, it keeps happening, or it's a new damage, so it's a new cause of action.
I'll address that. We vigorously dispute that. The same damages claimed in the small claims action are the same damages claimed in this action. The record appendix will bear that out. This was a 1-hour small claims trial. Ms. Shiel was represented by counsel. She introduced evidence, photographic evidence, documentary evidence. She had a full, fair hearing. That's the test, is under the res judicata principles. The test is whether the party against whom preclusion is sought has had a fair opportunity to litigate it.
Judge Colvin.
Clearly, she had. She did.
Judge Colvin didn't reach that issue, right?
I'm sorry, Your Honor?
Judge Colvin didn't reach that issue of res judicata.
Judge Colvin
He decided, based on the Massachusetts rule, he dismissed the case.
did not formally reach that.
So you want us to reach the issue that the
He
trial
did not.
judge didn't reach?
He decided the issue based on the Ponte case, as the clerk magistrate had. The clerk magistrate expressly put in the decision, Ponte versus De Silva controls. Judge Colvin, who wrote a fine opinion, said essentially the same thing, and said, in our brief, argues this, that as a trial court, he has to adhere to Ponte, as do the intermediate appellate courts. It doesn't mean that he rejected the argument. In fact, as we were leaving, he indicated that this was not the case to bring up to the court, to the SJC, because he felt that there were procedural infirmities with this case. And we argue that, obviously, the cleaner way to get from point A to point B, from Judge Coben's perspective and the appellate division, was simply Ponte controls. No need to get into res judicata. And that's how we briefed the case, Your Honor, to the appellate division and to the appeals court. Obviously, the dynamics change now that we're here. But I think that the res judicata principles apply. There are identity of parties, the same exact causes. She claimed $12,500 in damages in the small claims case. She acknowledged that she...
Is the small claims case in the record here?
It's all in the appended records. There's a 63-page transcript. I went out and got the transcript from the small claims hearing. She testified at length. She claimed $12,500 in damages. She submitted records from a company called Rebuild It, from a carpenter, from a roofer. And when we did our discovery on this case, the exact same documents were produced. The exact same financial claim was sought, $12,500 in both cases. So there is no separate action. There is no continuing action. And I think we should emphasize here, all of the cases cited by my brother have some real damage. They have, first of all, 4 of the cases cited are strictly invasive roots cases. They're not tree cases. There are only 2 pure tree cases, the Herring case from North Dakota and the White Cell case, the Hawaii case. The other cases are roots cases. They don't apply here.
Do we have a different rule for roots?
That's the Mickelson versus Nutting case. That's 1931. It's the same rule, but the attack here seems to be on Ponte rather than Mickelson. So we would suggest they're both good law and they both control. But I think those cases can be easily distinguished. First of all, 3 of them are just simply intermediate appellate cases. They are not even cases from the state Supreme Courts. 2 of them have dissents. 1 was a 2-1 opinion. One of the dissents in the North Dakota case speaks highly of the Massachusetts rule. The dissenting judge in that case says, we don't need to change that.
We have to decide whether or not to continue the Massachusetts rule and the wisdom of that rule. Why should we continue it? On policy grounds, why should we continue this rule if it makes no sense?
Well, there's no good reason to change. This court has a lengthy history of adherence to precedent. There's good precedent here. Our research has determined no case, and there's no case in this record, that criticizes Ponte or Mickelson or calls its vitality into question.
But why is it a good idea?
It's a good idea because this court has always urged surety in the law, certainty in the law. It's good because these cases they're from different jurisdictions, different geographical topography. There's not one case from the Northeast. There's not one case from New England. The closest case, I think, is Virginia or Tennessee. The land mass is different there than it is. Certainly Hawaii is different.
Other than saying we're right because we're right, why should we continue this as a policy matter?
Well, because, again, it's good law. It should be the law. It remains the law. There's no compelling reason to...
Because of notice? Because the homeowner who has the damage from the tree knows it's happening versus the tree owner? Is that a good policy reason?
I'm sorry?
I'm trying to give you an answer to his question.
Fastball down the middle.
Well,
Is it because the person who's getting the damage has notice that the damage is occurring? Is that the reason for the rule versus the tree owner who wouldn't know?
Exactly.
Is that a good policy?
These cases, the cases cited by the other side, they all have some notice provision here. I think it's important to note that this case, there has never been any instance of a tree branch falling on Miss Shiel's property and breaking the roof, breaking the garage. All of those other cases have that. They're very different fact patterns. They're much more compelling
But that's not really what we do. I'm just trying to get a sense. What is your understanding of the difference between, I'm reformulating Justice Gaziano's question to you because I'd really like an answer. What is your understanding of the difference between the Hawaii rule and the Massachusetts rule, and why is that difference not good? Why should we not go there?
We should not go there. The Hawaii rule...
And please don't answer because it's, I understand stare decisis and precedent. I think we get that part. We're just trying to get a sense of, is this a better rule or not? Why not?
We think that it is, Your Honor. The Mickelson case talked about innumerable and vexatious cases. That same language was adopted by the North Dakota case in Herring, in which they indicated the dissent that there was a concern about numerous cases. Now, my brother has argued that this is just a narrow exception. We very vigorously disagree. These cases, I think you have to look at the context. This is now the second case that my clients have been sued by Ms. Shiel. These are neighbors who don't get along. What better way than to go out and cause trouble with your neighbor, to go out and file a lawsuit in small claims court? We do think.
I'm just trying to get a sense. From my understanding, and I may not really understand the difference yet between the Hawaii rule and the Massachusetts rule, but the Hawaii rule allows you to bring suit against your neighbor, including with a healthy tree, that poses an imminent danger to your property. And Massachusetts says what you can do on a healthy tree is just cut down the encroaching branch. And I think your brother argues there's more, by allowing you to go to court, you're providing a little more flexibility into the system. And I may be mischaracterizing the rule, but is that not a good thing or why is that not a good thing or a bad thing? Because it will, and it also will deal with the fact that sometimes the tree is gigantic and it's very hard to sort of, on your property, go up there and knock it down. So why shouldn't we extend the rule a little bit to deal with that problem?
Well, again, I think
We're not just deciding your client's case, we're deciding a rule that's going to apply to lots of cases.
I think the concern is, in our situation, as well as some of the other cases that have been cited, again, the numerosity of potential for new cases to come out, vexatious cases, serial cases. Under my brother's interpretation, the argument he's made to this court, anybody could go out the next day and file a lawsuit against their neighbor because they don't like the leaves that are coming down. They could do that day after day after day.
The Hawaii case says that leaves coming down and fruits of the tree are not, and shade are not recoverable, that it's only this imminent.
Well, those are the facts of this case.
Well, I know you could win under Hawaii too, and you may very well, and probably will, if it's all it is that shade and rain. But I'm just, again, it would be helpful, because you're an expert in this, to know why the one rule is better than the other from your perspective.
I would suggest that even under the Hawaii rule, I agree with you on it. I think we would win. The Hawaii rule requires actual touching of branches to the property, the offended property. We don't have any evidence of that here in the record. It requires sensible harm, palpable harm. We don't have any evidence of that here in the record. We have substantial evidence in the record that this complaint of damage was actually old damage. So the facts here are vigorously contested. I guess what we're saying, this is not the case. If the court is interested in reviewing Ponte or Mickelson, this is not the proper case. The facts here are not compelling. The plaintiff's own daughter testified in our favor at the small claims hearing, saying that damage to the interior of the roof wasn't caused by the tree. It's been there for 12 years. There's no expert evidence in the record causally relating any of these claimed damages to this tree, which doesn't come anywhere near the property.
Let's go back to Justice Gaziano's facts and tell me how it would work under Ponte versus De Silva and Mickelson. So what if the roots from your neighbor's tree are starting to impact your septic system or your fence? Under Ponte versus De Silva and Mickelson, how does that work now in Massachusetts?
Again, self-help is the only remedy, unless, of course, neighbors can agree to try to handle this in an amicable way.
So they get along as swimmingly as these plaintiff and defendant?
Absent that, you hire a company, you dig up the roots, and you eradicate the problem. That's the law. That still is, by the way, still the law in all of these 6 jurisdictions that have adopted the Hawaii rule. They all have retained, as an express part of the opinion, the self-help. So I think it's also important to note most of these cases were cases of first impression. So this notion that, well, they rejected the Mass rule, I would suggest is a little bit of an overreach. They had the choice of 3 or 4 different approaches. the restatement approach, the Virginia approach, and the Hawaii approach. In most of these appellate cases, went through it and said, well, we think the Hawaii approach is the better approach. It wasn't this demonization of the Massachusetts approach. It was simply, well, we think this is better for us where we are, whether it be Hawaii or North Dakota or New Mexico.
What's the restatement approach?
I'm sorry, Your Honor?
There's a restatement approach?
The restatement approach is disfavored. It's not really, the restatement suggests a dichotomy between a planted tree and a natural tree. It's unworkable, and it's largely been put aside. There really is only one approach now, the Hawaii approach. Virginia, for some period of time, had a requirement that the tree be noxious, but that's been eradicated, so essentially Hawaii is the alternative approach. But I think the Chief Justice was asking some questions the other day, a few moments ago, of my brother, and suggested to me of the language of Ponte, in which Ponte says, this approach where we allow recovery is unworkable. And it is unworkable. From a logistical standpoint, going forward with the model that my brother would have this court adopt is unworkable.
Well, I'm confused by that, because in Justice Gaziano's hypothetical, you bring a suit that says the roots are going to destroy my septic system. I take it, the answer is, okay, how much did it cost to remove? It's basically imposing the cost of doing the project on you rather than on him. It's shifting who does the work, isn't it?
That's true, as a matter of fact, but the cases
But it's not-
uniformly
then
say
it's not
this is the
unwork-
natural process.
But it's not unworkable. The law is not unworkable. It's not that I hate to break it to you, this is probably not the most complicated thing to figure out. I'm not sure what the right rule is, but it's who pays, right? One side pays lawyers to sue the other, and then the other has to do the work, as opposed to you do it yourself.
In a perfect world, yes. This case is illustrative of why wouldn't work in a practical sense. Many neighbors don't get along. The worst cases I've seen in my practice are neighbor disputes, which is what this is at bottom. It's a neighbor dispute. So I think to suggest that it's workable, I may not be a realistic view.
All right, thank you.
Thank you.
All right.